On this episode of Through the Pines, we'll discuss preparing for estate settlement, including what even is an estate settlement, what generally needs to happen, and what happens with your home. How are personal assets handled? What about bank account transfers, IRA beneficiaries, life insurance implications, annuity challenges, and why you need a trust? Welcome to a financial planning podcast with a down-to-earth vibe. Sasquatch listens while making AI photos of himself in public and having a great laugh about it. This is Through the Pines. Our advisors for this episode, we welcome back Rex.m.baxter and Brandyn Smith from planwithbaxter.com, 2023, 2024, 2025's Forbes Best In-State Wealth Management Teams for Utah, Advisor Hub's fastest growing advisors to watch under $1 billion, and the receivers of the Ameriprise Client Experience Award, which means they know exactly what they are talking about. Planwithbaxter.com. Rex, welcome back.
Thanks. This is where we make boring topics fun.
Well, we do our best. We certainly try. And I mean, I know there's not a lot of people probably searching on the AIs in Google for preparing for estate settlements, but when it happens, you're going to need to know these things. And it's very important. And I was thinking about this in another, it was like buying a car. Actually, it wasn't buying a car. It was like when you get in an accident and you have to do but people will take advantage of your naivete. And so, unfortunately, this is one of those situations where that could potentially happen. So the more you know, the less, and I hate to be cynical like that, but it's quite possible that could happen. And so as long as you have your stuff prepared ahead of time, so that you are ready for these estate settlement when it comes up. So Brandyn, do you want to start off by just simply explaining what an estate settlement is and kind of defining it so that we can have a ground zero to work from?
Yeah, that's a great question. Thanks for having us. So estate settlements are when someone passes away, typically the last spouse, if you have, parents that are married, the last one that passes, there's an estate settlement that goes on, which is essentially how are all the assets divided up. Mm-hmm. And that can go a lot of different ways, right? It depends on what assets they have, depends on what, estate planning they've done. And so really this is one of those topics we get asked a lot of questions on and almost, I wouldn't say in a panic, but kind of nervous, right? People come to us and say, oh, my mom just died, my dad just died, and I have no idea, right? I don't know what this means tax-wise. I don't even know where to start. And so we were hoping we could do this podcast to really help people, if you're preparing for, beforehand, say, wow, mom, dad, getting up there in years, I want to make sure I've got all my ducks in a row. Or if you just, recently had someone pass and you're like, where do I start? Hopefully this can be a really good podcast for you to figure out, all right, what are some of the things I need to consider? Obviously, we're not estate planning attorneys. We're not giving legal advice. But we do deal with 2-3 estate settlements every year, typically. And then usually have a few people come to us beyond that. And so we deal with it plenty. And so hopefully we can kind of go through the different assets that there are and how to deal with those. So yes,
talk about Rex. Bring this in. Talk to me about the financial side of it, because you said you're not attorneys. So what's the difference there?
Well, the
as far
difference
as what
is
you can
I can pass a law degree.
Yeah.
And so there's a lot of misinformation out there on estate settlements. We help with the process of the estate settlement. So we help with the retitling of assets. We can help a little bit with the distribution as far as moving things from one title to another title, or we can provide guidance along those lines. But we don't draft the actual documents, and so we don't draft a will. Our group does not draft the actual trust, which is a legal document. We don't draft contracts, things like that. That's where you need a law degree, and that's where an attorney comes in. However, we can work with the attorney to help guide and interpret and brainstorm on those documents. And so when we get into the estate settlement, we've been through enough of those discussions that we can help guide you on the processes of getting that done. And if we have legal questions about what does this phrase in this part of the trust mean, then that's where we would go and ask an attorney for some clarification on what does this phrase mean, and can we distribute it in this sort or this fashion.
Rex, are there ever disagreements or contradictions between the financial planner and the estate attorney?
Yeah, I wouldn't say disagreements, but more clarifications. It feels like every estate attorney has their preferred way of doing things. And so sometimes they'll have a preferred way of how they want the beneficiaries listed, or they'll have a preferred way of phrasing different backup trustees. Or some attorneys, especially in some states, prefer to have what's called like a springing trust and not have a trust created during their lifetime. And so, each will have their preference, as we have our preferences through experience, through 30 plus years of experience. We've seen what works really smoothly, and we've seen some things that don't work smooth at all. And so we have our preferences on look, if you do it this way, then here's the pros and cons of that. And here's some hurdles that you may encounter if you end up following that guidance. And so let's talk to the attorney and see what his plan is to overcome those hurdles.
Yeah.
And that's where we would get into a discussion point, and that's where we work closely with the clients and their estate attorney and their accountant to make sure that we're all on the same page.
Okay. Brandon, can you take us through generally what needs to happen in an estate settlement? Is it prep, like on the prep side?
Yeah. So, and it all kind of melds together, right?
Yeah.
And so really I thought it would probably make the most sense to talk through the different asset classes that there are. So how is a home passed? How are personal assets like vehicles, ATVs, wedding rings passed? Bank accounts, IRAs, life insurance, and annuity. So why don't we just start at the top with home?
Perfect.
And so there are a couple different ways that a home can be passed. Our preferred
I think
method,
I know the answer because I've heard this on the show before. If you've listened.
Yeah.
You just sign it over to the other person
That's not it.
before you die, right? That's how you do it?
That is not the preferred method, Brandon. You need to go back and re-listen with open ears and clear eyes and things like that.
Yeah, okay, but that is the assumption. So what is the actual way, Brandon?
Yeah, so people will do that, right? Because they think, man, I don't want my house going through probate. Probate takes time, right? You can have some disputes and things like that. And so why don't I just sign the title over to my child? I'll be a joint, and the issue with that, right, is obviously we've got tax implications, gift taxing potentially, but even more so, you lose your what's called a step up in cost basis when you die. And so typically, right, if a home is passed through probate or passed through a trust, your beneficiaries get what's called a step up in cost basis, meaning let's say you bought the house for $150,000, it's now worth $600,000. If you were to sell that, you'd have capital gains tax on the difference. But if you were to sell, if you pass that on to them via trust or probate, they get a step up in cost basis at the date of your death. So if it's worth $600,000 when you die, it's like the kids bought it for $600,000, and so they don't. Essentially, it stops them from paying capital gains tax on the house. So we really want to avoid just putting kids' titles on the house. And so that brings us down to, all right, well, what are the options? First one is probate, right? So you just leave the home in your name, and then it will be up to a probate judge to assign the beneficiary of that, right? Typically, a probate judge would look at a will if you have that. Typically, they're just going to give it to the kids. A lot of people don't like that uncertainty, though, right? That it has to go through a time period. You have to wait for a judge and a date for that. And so what people will do is create a trust. And then the home will actually be owned by the trust. And then the trust will dictate what happens to it upon your passing. And you have full flexibility. We have some clients that say, hey, man, when my parents passed, we kept the house for a year or 2 years, and that was really nice. People could come, stop by the house, pick things up. They gave them time. And so they write that into their trust and say, hey, you can sell my house, but I want you to wait 12 months after my passing. Is that the right answer? I don't know, right? It depends on what you want. Most trusts just say, hey, liquidate the house within a reasonable time frame, and split the proceeds between, the beneficiaries of the trust. But typically that's our preferred route, is to have the home owned by the trust, so that then we can avoid probate. We don't have to deal with the judge or anything else like that. And the successor trustee can then have authority to sell the house.
Okay, Rex?
The other part of probate is normally you have to put something out in a publication for 30 days to allow any
dangerous?
creditors or anybody that wants to contest it or challenge it. And so then that's how it becomes public notice.
Mm-hmm.
And on top of that, all of your assets, if it goes through probate, are listed out in that court proceeding. And so, you talk about bad actors sometimes, and they can go through that probate case and say, oh, wow, here's, not to pick on your last name, but Mr. and Mrs. Smith, right? And they passed, and they have X amount in a house, and they've got this other real estate, and they have this asset and that asset. And so let's go in and see what we might be able to get at really cheap prices.
Well, yeah, and if I'm a crook, I mean, you get good at that probably.
Right. It's public information at that point. And so that's why we try and avoid probate. A lot of people, one of the most common questions and misconceptions, and even sometimes we'll have some attorneys throw that out there that, the estate tax limit is over 13 million, almost 14 million for each person in the married couple. So if you're married, you can pass up to 26 million, 27 million to your heirs tax-free without a trust. And that is absolutely true. You can do that. And so a lot of times the attorneys will say, well, you don't need it for estate tax reasons. You don't need a trust. And although that's completely true, the trust also simplifies and streamlines the passing of the assets between your heirs and keeps it so it's not in a public forum.
Mm-hmm.
And I think that's the primary reason that we'd like to see people complete a trust and get that part of their estate planning done.
Brandyn, does this apply to like non-owner occupied homes as well, like rental properties as well? Like how does that work?
Yeah. So it depends on who owns it, right? And really the way to think about this is who has authority to buy or sell the asset. And so if it's in an individual's name or a joint name and one of the spouses has passed, right? So now it's in a single owner name and then they pass, who has authority to sell that asset? Like nobody, right? And that's why it goes to a judge. That's the legal process. That's the reason for probate, because we don't have anyone who is legally listed as able to sell the property. And so we go to essentially an independent judge, right, to say, all right, who gets the asset, who gets to sell it. Mm-hmm. And same is true of like a real estate, like investment property, right? If you have it in single name and you pass, well, who gets to sell it? Unless there's some sort of trust document that says, oh, actually, if this person passes, then this person has authority. If they aren't able, then this person, right? Unless you have that order, that authority is listed out, then it has to go to a judge. And that's essentially the essence of probate. Mm-hmm. is, hey, we don't have anyone that can sell it, so we're not going to hold it in their name into perpetuity. We have to assign someone else the authority.
Frequently, we'll have somebody say, well, but I own the investment property in an LLC, in a limited liability corporation. However, the owners of the limited liability corporation are the individuals, the husband and wife, typically. And so again, when the husband and wife pass, there's nobody there that then runs the LLC. And so the court, again, that LLC ends up in probate. The court appoints a personal representative, and that personal representative then becomes the executor of the estate and can handle it. But again, you're dealing with all that time and nuance. And so a lot of times what we'll see different attorneys do is they'll have the trust own the LLC. So the LLC operates the property, the rental properties, but the trust owns the LLC, and therefore the trustee, when mom and dad pass, the children or whoever those trustees are can still operate, run, and sell the properties that they need to, that are the investment properties.
I don't know if this was just an epiphany or what. I guess I just didn't realize that the trust can own the businesses.
Yeah.
Sure.
Okay.
Sure. Yeah. So a trust is just an entity
Yeah.
And if you think of that, it can own businesses, it can own real estate, it can own different things. Now that does, and you'll get some attorneys that can get fairly complex fairly quickly, but you'll have some attorneys that say, look, you don't want your trust to own the LLC, because if the LLC gets sued, it could open up the trust, as far as financially. And so there's some give and take on different ways to do that, and when to have the ownership passed to the trust. And so you want to work closely with an estate attorney on those things.
One other thing, if you're going through this process and you're like, I don't know who owns the house, right? I see a trust, but who owns the house? You can look up usually on just county records and do a property search the address, and it'll pull it up. And if it's individually owned, you're going to see the names, right? This is Brandyn and Jessica's house. If it's owned by the trust, you'll see the Brandyn and Jessica Trust, Living Trust, whatever it is, and you'll see that on there. And so you can look it up that way if you're not unsure.
Is it public, or
public.
would you need to just call a title company, any title company, and kind of go that way?
It's most of them are public.
Okay.
I mean, you just go on a county website, type in the address, and you can see who owns it.
Some counties' websites are a little easier
fair.
to look things up on than others. And so, but it is all public information. So you could go in right now and type in an address, and it will tell you who the owner of the address is, whether they're up to date on their property taxes, what the ownership history is. Yeah. That's all public information on the county recorder site.
Okay. So does that cover home transfers?
Yeah, I think
pretty much. Okay.
Yeah, I think so. I think the takeaway is that we don't want to lose that step up in basis on your home.
Yeah.
Yeah.
And if you transfer title prior to death, then you run a significant risk of losing that step up in basis.
Yeah. Okay. Very good. What about personal assets? So, Brandyn, you touched on this for a second. Now we're talking jewelry, watches, that kind of stuff.
Yeah, vehicles, toys, ATVs, trailers. And so I'd say there's probably two groups in this category. One, assets that have a title to them, and then assets that don't have a title to them. And so vehicles, it's interesting. Some attorneys say, hey, you should have the vehicle owned by the trust, and you can do that, right? You can, when you buy your car, you can buy it as the trust, and then the benefit to that is that if you pass away, then the successor trustee has the authority to go and sign and sell the vehicle. There's a lot of people that have, say, downsides to that, right? More paperwork. It's a little bit, people don't understand it as much. I've heard attorneys argue that, if the trust owns it, then if you get in an accident, someone might be like, wait a minute, there's a whole trust attached to this. Like, let's see what assets are in the trust, right? If you're trying to litigate against it. And so, for simplicity, a lot of people just don't put it in the trust. And part of the reason for that is, at least in Utah, right? If someone passes, you can just file a small estate affidavit, and it's really just not that hard, right? You bring in a death certificate, you go to the DMV, and you can get the title signed over, and you have to wait like 30 days. There's a little process to it, but it's just not that difficult. And so a lot of people will leave vehicles outside of the trust.
Okay.
I would say, because we have clients all across the country, right, that small estate affidavit varies drastically from state to state. And so, in the state of Utah, I think it's $100,000 for the state, for the small estate, meaning that if your estate is under $100,000, then you can bypass probate and just pass it through the small estate affidavit. In Oregon, which I think has the highest, it's about $270,000 is their small estate affidavit, and then there's a handful of states where it's only $10,000. And so Georgia, one of the Carolinas, and things like that. And so you want to look and see in your individual state where that small estate affidavit is, and see if that's going to be applicable or not. But titles to vehicles are really rather simple to pass, just with a death certificate. And so you can go down and
that's good to know. I guess I didn't realize that. Okay.
Yeah. So that's a pretty simple process.
With the price of cars, though, you start getting a couple cars and a toy or two, and you might start pushing on some of those limits. And so you want to kind of pay attention to
that. Side note, Rex, I was watching a financial news channel.
Wow.
And they had a watch guy on there. Okay. And he had like 5 watches, and they were mostly 5,000 and over to buy these watches. And his claim was, do not buy these as an investment. They are not investments, but they will hold value. What is your thoughts on that?
Yeah, I think
on watches as investments.
I think rarely do you get the money out of them that you put into them. You know, we have some clients that love their watches. Matter of fact, I just had one that had a big year last year, and his gift to himself was this nice Rolex, right? And so he picked up a Rolex for, I don't remember if it was 50 or 75,000 or something like that. You know, a fairly nice watch.
Fairly nice. Mine started reaching $500. I'm like, whoa, that's an expensive watch.
Yeah, I think I'm still using a Cracker Jack watch. So, yeah.
Okay.
So, so I think it depends on, you know, I think some brands will maintain their value better than others.
Yeah.
I think sometimes you have different metals, or, you know, in there, or you may have some diamonds or different things like that that maintain and appreciate their value inside of the, so I don't think you can draw a straight line and say, yeah, they're terrible investments or they're great investments. But I think most people are buying, I think rarely are they buying watches or jewelry purely as an investment. Generally they have a personal, you know.
Okay. Well, as that pertains to the podcast, that is a personal asset, or is that a personal investment? Like, how does that?
So that's an asset, right? It's a personal asset that doesn't have a title typically to it.
Even though it's $100,000 watch.
Yeah, it's still something that, you know, typically when you do an estate plan and you have your trust and your wills and what we call pour over wills or just in case wills, things like that. They also have typically what's called a personal asset sheet or a Schedule A lots of times, where you'll have a blank sheet with a bunch of lines on it. And on that, you'll kind of put a date, what the item is, you know, my Rolex watch, serial number, you know, ABC123, and I want it to go to Joey, right? And that's how that passes, is literally just through that instruction. We've seen families that use Post-it notes, and they'll go and they'll put Post-it notes on different things for the family throughout the house.
What happens if Joey is the cat?
Then the cat has one fine watch.
But you can do that with a trust.
Yeah.
And we've actually seen that, right, with clients that have animals that they love, and they're like, hey, you know what? This cat is going to have an amazing rest of its
Fancy
life.
Feast or someone make that a commercial?
Oh, I don't know.
Yeah, they did.
Oh, that's funny.
They did, in a fancy house.
Yeah, the whole family was around, and then everyone thought they were going to get what they were going to get, and then the
estate goes to the cat.
Right. So,
yeah. And essentially, the way you do that is just write the trust, say what you want to have happen, appoint a successor trustee to make sure that happens, you know, and you can do that for the life of the animal and then split it after that.
Yeah, we have a client with a bunch of border collies, and so the border collies can be very well taken care of during their lifetime. And so
this is wild.
Yeah.
This is wild. Okay, so personal assets, does that wrap it?
Yeah. I guess one other thing on vehicles, titling of them, you can do, you know, individual name, you can do joint name, so two people can be on the title, and then they always ask and or, right? Is it Jessica and Brandon, or Jessica or Brandon?
Oh, big difference.
And it is a big difference. Yeah, it's who can sign and sell, right? So if it's Jessica and Brandon, then we both have to go to the DMV and sign our name if we're selling the asset, or not to the DMV, right? But we both have to sign. Or if you do then one person has authority to sign. And you'll see that throughout estate planning. But I think that and or is a really important indicator to just kind of keep in mind. And it comes down to what you want to have happen. Not one is not better than the other. You know, if you fully trust each other, then just do or, and it's more simple. Or if you want an extra check and balance, then you do and, so both people have to sign off on something.
Okay.
Some couples will put their kids' names on their titles, on the vehicle titles before they pass, and so they'll put Joey or Jill or whoever.
So do it to the car, but not the house.
So there's still some pros and cons to the car, right? It's not as if we're getting a step up in basis on a car,
appreciating
because it's going down in value. But you are opening yourself up to litigation if you put somebody else's name on there. And so if you put, you know, Joey's name on there, and all of a sudden he goes and you know has a DUI one night and hits somebody and kills somebody
in a different car altogether.
Oh, really?
Then all of a sudden that opens up that other vehicle to that lawsuit, because they're a part owner of that vehicle now.
Yeah. Okay.
And so it can open up additional litigation, and you being part of, you know, if it is that same vehicle that they're in and they get in that accident and it's that same vehicle, then all of your assets, because you're part of the owner of the vehicle that was in the accident.
Not good.
right? And so you really want to think through that as far as when do I want to put somebody's name on these different assets.
Okay. All right, that's a big deal. Okay, so Brandon talks to me about how easy it is to just transfer bank accounts.
Yeah, actually fairly simple.
Really?
Yeah. So if you do it right, I guess that's
If
true
you do it right.
true
In
of
an
most
estate
things.
settlement situation, I should add. But yeah.
Yeah. So banks, and one thing people don't understand about banks and IRAs and life insurance and 401ks, we're going to go through these, but most of them you can appoint a beneficiary, right? You can designate a beneficiary, and that trumps. Right? Like, it doesn't matter if you've got a will. It doesn't matter if you have a trust. It doesn't matter if your trust and your will both say, hey, no matter what, I want all of my assets moved to here. If you've got a beneficiary listed on a bank account, it's going to that one person.
Which is a good reminder to update your beneficiaries, especially if you've been married more than once.
Yeah, very much so.
Yeah.
Because it does, it's going to follow that. And so with banks, there's a couple different things, right? You can, a lot of people have like on a, we'll go with banks and non-qualified accounts, I think, is an important designation. So
And just
when
to
I
clarify,
say non-qualified,
banks and credit
Non-retirement
unions.
accounts.
non-retirement investment
And
accounts.
the credit unions are the same? Like,
Yeah, so
okay.
a bank account, a checking account, a savings account, or a non-retirement investment account where you may have some stocks or mutual
We're
funds.
talking all banks, even like an online-only bank.
Even non-brick and mortar.
Okay. All right. Just want to make sure we're all okay.
Even crypto banks.
Even crypto banks.
Yeah.
Okay.
Yeah, this is very applicable to any place you put your money that's non-retirement account, non-IRA, non-401k, whether it's in a bank account, whether it's in an investment account that you're going to get your 1099 on each year, right? You can designate the ownership, and then you can designate beneficiaries. And so you can appoint, a lot of times with investment accounts, we want the trust to be the owner of the account. And that way, if someone passes, right, we don't have to set, like, you have a successor trustee that then has authority over the account. Bank accounts, you can have the trust own a bank account, and the benefit to that is the same thing, right? That we have successor trustees, everything appointed. The other thing you can do is you can do a payable on death or a transfer on death. POD or TOD is the acronym that you'll see on there. And what that is that way it's your asset. You don't have kids.
Isn't POD a band? Payable on Death was like a punk band.
Really?
Your wife would know.
She would. I'll have to
I
ask
think
her.
of PIL. I don't know
PIL
about
was
POD.
100%. I think POD was too. PIL, I will argue, was way better than POD, but that's another story. Yeah.
But we digress.
But those designations just basically say, all right, if I pass, then this asset completely passes to this designated person. Right. And the benefit to that is you have full access and control. They don't have any control while you're alive. But if you pass, then they can bring a death certificate in and say, hey, I'm the beneficiary, and they can have access to the account.
Yeah.
And so, yeah.
With an ID.
What?
With an ID, with a little star on the.
Yeah, a little star.
Star and a death certificate.
Yeah.
Right.
Yep.
But normally that still doesn't have to go through probate.
Right.
Because it's passing by beneficiary. And so sometimes you'll get estate attorneys that will say, look, we're not going to do a trust. What we're going to do is we're going to make sure all of your accounts have a beneficiary attached.
That seems like the easiest at first, the easiest way to go, right?
So it's a way to go, right? Because
Okay.
you need to also make sure that you have powers of attorney, because the other benefit of having a trust is it kicks in at incapacity as well. And so if you're in a care center and you have Alzheimer's
Excellent point.
or you have something else, but you're still living, right, then that asset doesn't pass to that next generation yet. And if you don't have it in a trust or you don't have a power of attorney, either immediate or springing, and if you want to hear more about that, we have another podcast talking about estate planning. But then essentially it's stuck, right? You have to go to court and you have to get appointed as a guardian and a custodian over that person and over their assets. And then you can start to control, but it again takes time and money to go through those processes. And so if you forget an asset, or you change banks, or you open up a new account and you forget to put the beneficiary and you don't have a power of attorney in place, then it can get messy really quick. And so that's what we're trying to clear up is, we want to keep things as clean and simple as possible.
Yeah, for sure. And I appreciate that.
Thank you.
Okay. Okay. Anything else on bank account transfers, Brandon, in estate settlements?
No, I think I'd just say preferable to have it owned by the trust. Usually makes sense, especially as you're getting, on in years and the likelihood of a premature passing. Most people will just have a bank account like joint with rights of survivorship, right? So if I pass, then my wife gets it, or vice versa. But then, especially, later on in life, we like to see that owned by a trust. It's just more simple.
Yeah.
And if you don't do that, just make sure you're checking beneficiaries, so it ultimately gets to where it needs to go.
Okay. All right. Well, let's move on then to the qualified accounts like IRA and 401k type accounts, Brandon.
Yeah, so IRAs are fun, and let me just start this with a story that I've experienced way too many times. But
or bad.
Yeah, bad. No, I've had a lot of people that they'll say, hey, yeah, just put my oldest or my second child, they're the responsible child, put them as the IRA, they'll know what to do with it. As the beneficiary of the IRA, they'll know what to do with it. And I always try and talk people out of that, right? Because the issue with that is, and I see it way too often, but the issue with that is now all of a sudden legally, that IRA, if the first person passes, the beneficiary, that is their IRA. They are under no legal obligation
to give it to the sister, brother who they just had an argument with, and this is not going to end well.
Right.
Okay.
Right. And so that's major problem number one. Let's say that's not an issue. Let's say they're the most kind, well-meaning, and they say, okay, I'll pass this to all of my siblings. Well, now when they pull the money out, it's taxable to them as income.
Because they're the owner of the account.
Owner. It's an IRA distribution.
So if they distribute to any of their siblings, they're paying taxes?
Right. And we can withhold for taxes, fine, right? It's really hard to get that exactly perfect, but we can withhold for taxes. But now all of a sudden we're taking all of it, we're piling all the extra income onto one person.
Yeah.
And so we far prefer to just list the beneficiaries.
Okay,
right?
so this is the question that maybe people don't think. So they say, who is your beneficiary? And that presumes that there can only be one.
Sometimes, right. Yeah, they think that. Who's my beneficiary? Well, my wife. Okay, well, there's the one, right? Or my husband. And, okay, well, who's your backup beneficiary? Because, and it's just terminology. Instead of beneficiaries,
right?
People will say beneficiaries.
Yes.
But yeah, you can have as many beneficiaries as you want. Now, I will say most bank forms allow, have space for 2 or 3.
Right.
Yeah.
And so,
ask for an additional forms, but yeah.
Yeah, we're in Utah, right?
We're in Utah, and I have 7 kids, and so I have to do an extra,
that's how you know.
3-page diagram, right?
Okay, yeah.
And so,
oh my gosh.
But there's also other unintended consequences.
We're going to need a bigger paperclip.
We need a bigger boat.
Did you know that line was not written in there, and they decided to use it later, and it became one of the most famous movies in Jaws?
Really?
Yeah, it was originally not written in the script.
I didn't know that. Yeah. That was just ad-lib.
We're going to need a bigger boat. Yeah.
Oh, that's funny.
Anyway.
That's funny. No, I think some of the other unintended consequences, right, is if you have just for the sake of example, you have the oldest child, right, listed as the beneficiary. It all goes to them, and then they start taking money out to distribute to the other kids. Not only are they responsible for the taxes, but because it's going through their tax bracket, it may make more of their Social Security subject to taxes. Mm-hmm. It may increase their Medicare cost for the next year. It may increase. I mean, there's all these other unintended consequences.
Particular person, they may be successful in other ways and already have a high tax situation. So that just adds to it, right?
Right. Yep. So it may be taxed at a higher rate than had we given it to, the child that's unemployed.
Or split it, right?
Right.
Well, idea here. So
that's the answer, right? Is we don't want to give it to one child.
Right.
Even that strategy, though, may be tempting. Like Joey's in a 0% tax bracket.
Right.
Let's take this out. Though tempting, we really do want to list individual beneficiaries. And what that will do as children is you pass that IRA. And we'd open up inherited IRAs for each child, and then they'd have 10 years to take the full distribution out of the account. They can decide, all right, how much do we take and when do we recognize the tax on that? And so that's the preferred way that we like to do it. Every once in a while, though, we have clients that are like, oh, I don't know, I don't trust so-and-so, or they're always just, squandering their money, or there's substance abuse issues. And I really want to control how this is passed. And so then in those cases, we can actually list the trust as the beneficiary. It does add some complexities depending on how the trust is written. Sometimes that distribution period goes from 10 years to 5 years, which can make it more difficult tax-wise. Most times there's extra tax filing that's required when you do it that way. And so we really prefer to have individuals listed. However, if we're concerned about how the money is spent and we want to control that, we can list a trust and actually have it flow through the trust. And then, whatever you've listed as the requirements for distribution in the trust will be followed.
Yeah.
Or you can blend it, right? We just had one family that, they have 4 of the kids that they're healthy and self-sufficient and things like that. And so we listed the 4 individually, and then we have a 5th that has some special needs issues. And so we listed his springing trust, right, that will kick in upon the passing for his 20% share, essentially. And so there's not necessarily a fixed way that you have to do it, although there are certainly ways that are less advantageous to you, such as listing just one person and things like that. So.
And one point of clarification, in that scenario, that trust needs to be the trust of that individual, right? You wouldn't want to list like a quarter, and then the rest going to the general trust, right? Because then it just gets split between the general trust. Yeah. And so you'll want to have an individual trust that usually would be done if you do have concerns about a child, and taking care of them that way.
Okay. And I should mention, and this is a good time to mention this actually, because you're going to have questions. Like, there's a lot of information. You get the podcast for free, but and you get a call to planwithbaxter.com for free. But then you're going to have to you'll probably want some follow up, and that's why you do what you do.
Yeah, I think every situation is extremely unique.
Yeah.
Right. And everybody's going to say, well, here's my situation. And this is a little bit different than what you explained in the podcast.
Yeah.
How does this situation apply?
Yeah.
And that's where you should reach out to us and give us a quick call.
Good. Brandon, you have some s'more numbers for us?
I do.
Woo.
Yep. So this is from Junior Achievement. And I thought this was interesting. It says, despite nearly half of high school students, 45%, saying they took personal finance class, 80% of them haven't even heard of a FICO score.
What year was this? I mean,
just
recent,
barely.
Right?
Yeah. Which I think
at what age? Seniors?
Teens. So and so maybe they're younger teens. But still 45%. And I guess what's really interesting is it said 43% of teens believe that an 18% interest is a manageable debt. Which probably
that hurts.
has something to do with lately. That's what credit
the
cards,
rate on their credit cards.
A lot of credit cards are 18 to we even see them in the mid to high 20s.
Because their first experiences, at least one of my first experiences, was you go to the college campus, they're hitting you on the walkthrough. They're like, hey, there's this 23%er. Go buy
I've
your
seen a
books
number of them with teaser rates that jump to 33 and 34 now.
Oh, really?
Wow.
Yeah, up into that range. And so if you think about the math on that, that means your balance is doubling every 3 years on that card.
But your minimum is...
And your minimum might be $25, but you can manage $25 forever because you'll never get it paid off because it's doubling every 3 years. So, but that's a FICO score. So a FICO score for all those teens that are listening.
A lot of them on the estate settlement podcast.
For the 67% of teens that are listening.
to an estate settlement podcast.
Like, I wonder how grandma's doing this.
They're like, what can I get?
Grandma, put me on that title of that car. I want that Ferrari.
That's funny.
So, that's your credit score. And so that's what they use to determine whether a bank is going to give you a loan for a car or a loan for something else.
Yeah.
And what rate, what interest
rate.
Yeah. Yeah, it can make a huge difference. So, okay, let's chat about life insurance, shall we, and its implications in estate settlements. And are there differences amongst the life insurance types, Brandon?
Yeah. So as far as estate settlement goes, it comes down to the beneficiary again.
Okay.
Right.
Easy.
Almost all, and you have to say almost, right? Because there's some very unique situations, but almost all of life insurance is going to be tax free. And so just as I guess a quick kind of recap of taxes, homes typically get step up in cost basis if it's done right, comes to you tax free. Personal assets, right, have depreciated usually, and you don't have to pay tax on that. We're not talking estate taxes. Estate taxes, though, that's, you're above 13 million. And so usually that doesn't apply.
Right. We're talking capital gains taxes.
Capital gains tax. Yep. But a lot of people think that there's like some big sneaky, death tax. And as the tax code is written today, there's just not a lot unless you're above that 13 million. Even at 13 million, there's ways to get around it. So there's none. And so, we're not seeing a lot of death tax, I guess is what I'm saying. Non-qualified accounts, bank accounts, usually those will get a step up in cost basis if you've done it right? So you don't have inheritance tax on that. The IRAs, those are all those assets as they come out, they're going to be taxable to you as income. Unless it's a Roth IRA, then it's going to be tax-free. And then life insurance, usually tax-free on the proceeds. And so just a little, I think, a recap on that, because that's one of the number one questions I get when people are going through a estate settlement process. They're like, what do I need to expect for taxes? Right. And the good news is usually it's fairly minimal. But yeah, so life insurance, whether, it's whole life, variable life, term life, I mean, all of those are going to be completely tax-free on the death benefit. And again, on these, it's going to pay to the beneficiary. And so it doesn't matter if you've listed, or if you, have a trust that says, hey, I want all these assets. Whoever is listed on the beneficiary, part of the life insurance policy will be paid out in whatever split you do, right? And so you can do all the various kids, you can list them individually, whatever you do that way. A lot of times we see life insurance policies list all kids as the beneficiary, so it doesn't designate each of them. And if you do that, right, then you have to do an extra form, proving that these are all the kids, right? So you don't just get 2 of the 5 come and say, hey, here we are, we're the kids, Yeah.
Well, and again, you want to be careful on second marriages and things like that.
Yeah.
Because
when
you put all kids, it's going to be your personal legal kids and maybe not your husband's kids. And maybe you want to include both.
Yeah.
Or maybe you don't, right? And so you want to make sure that you're paying attention to that.
Okay.
Yeah. Kind of the process on that is you notify the life insurance company. So you find on the policy, there's usually a phone, like a 1-800 number. You call the 1-800 number. It's helpful if you have the policy number. So this is all, usually you can have that life insurance packet, right? The document that's showing you that there is a life insurance policy.
Right. But the kids or whoever's doing this needs to know where all this stuff is. I mean, this should be, that's one of the things we didn't really touch on, but that should be organized in advance, right?
It should be organized in advance and communicated extremely well in advance. Like for instance, with my parents, right, they've got a binder and they keep it in a safe at the house, a fireproof safe at the house. And we all know how to access it as far as the kids, and we know where it's at. But I am frequently surprised at how often that is not communicated to the kids, either where the documents are held, or what's supposed to happen and who's actually in charge. Sometimes they don't even, tell Johnny that he's the trustee over everything, and he's going to be handling everything. And so you've got, Joey sitting there expecting to do it, and now we've created some more family discord because somebody else is handling it, and Joey feels like, oh, they didn't trust me, they didn't love me, and
so binder, communication, do all those things.
Financial advisor, right? We get a lot of clients that will give us copies of things so we can keep it in their file.
Yeah.
Or we track it on their website. I mean, having a financial advisor for this is really nice to know where all the assets are. Sometimes we'll do just a quick financial plan that has everything listed. And so it's easy for us if someone passes to say, hey, have we found this policy? Because even if you don't have the actual policy, which is the best thing to do, is to keep the policy. But even if you don't have it, right, we can call the insurance company and have them look it up. And
is there a way to, so you don't know what insurance the person who passed is there a way to work backwards?
That's tricky.
Yeah.
Because it's not like there's a a overall
Right.
group
There's no
out there.
there's no database or anything.
Right.
So, okay.
To where you can just pull up by social security number and say, oh, they have.
So that insurance company that's never claimed, did they just keep the money? I mean, I don't know what happens.
Eventually it gets turned over to the state, to the unclaimed property division for the state. Once they've been notified that somebody's been deceased, then they have a certain amount of time, and each type of asset has different time constraints as far as how long they can house it and keep it, and until it has to be turned over to the state's unclaimed property division.
This would, I guess, apply to someone's worked 5, 6, 7 different jobs and forgot they had 401ks at some of these other jobs. Like, how does that work?
Same kind of thing. And so, although lots of times, like on 401ks, if they get return statements for 2 years or for some period of time, then lots of times that's where it has to get turned over to the unclaimed property division of the state. And so, at that point it gets kicked over there, and then you've got to start becoming a detective a little bit.
Oh, wow. Okay.
Which is not, I mean, so those are kind of the steps, right? Is if you think, hey, I think they had a policy with it, just call the company and you'll need a social and things, and they can look it up. Or check that unclaimed property website.
And then how do you prove that you're you? Because anyone could call the social and say,
yep, yeah. So that's what's funny about calling the life insurance companies, because they will not give you information.
Yeah.
What you can do though is you can call them and say, hey, I've got this policy number, or this person has passed. Here's the social, right? They'll pull it up and say, all right, we'll send a packet out, right, to the address on record. They'll send out a whole packet of things. That's going to have some requests, like a death certificate that they're going to need to see, the affidavits possibly showing, who the kids are and people signing off on that. And so they'll have a process. They'll send out a packet. You then fill out that packet, submit that back to them. They verify it, and then make the payments.
Okay.
Yeah, sometimes they'll require a government ID, like a driver's license or a passport, to kind of prove that you are who you are. Sometimes they'll require a birth certificate to show that they were your mom or dad. And so it just depends on the insurance company and what kind of information they want to require.
Okay. Brandyn, what about annuities?
Yeah, so similar to life insurance and the others and IRAs is it's going to go to whoever's listed as the beneficiary. Very similar to life insurance, right? You're going to contact the annuity company and say, hey, this person has passed. They're going to send out their packet that you fill out all the information, submit that to them. Different though than most of those assets is that the growth is usually taxable to you as income, and so there is no step up in cost basis. Whatever growth there is, you're going to recognize, right? That gets split between the different beneficiaries, and they'll recognize their portion of the growth as income.
If it's a non-IRA annuity, so then that's where that growth is taxable to you. If it's inside of an IRA annuity, then it's always interesting, because if you go straight to the annuity company, they almost always will just cash it out all to you at once. Instead of working with the annuity company and rolling that into an inherited IRA, where you can take a small amount and distribute that income over a 10-year period. And so that's where an advisor can really come in handy, as far as explaining different ways to do that and working as a liaison between you and the annuity company on the most tax efficient way for you to handle that distribution.
Okay. All right. Well, this is all really good information. And then finally, it all wraps up into a trust. And we sort of covered some of the reasons why you need one. And we have a full podcast on that. But Brandyn, anything else you want to add?
Yeah, I was just going to plug that podcast entitled Why You Need a Trust. We released that June 20th of 2024. And so, yeah, I'd say and we've done a really good job, I think, kind of high level with the trust. But trusts they have lots of flexibility. If you meet with a good estate planner, you can really design something to help distribute your assets however you see best, after you're passing to your beneficiaries, whoever those are, whether that's charities, kids, whatever you want to do, you can really customize that. Really, they help you designate who gets what and when. And so, we're big fans of trusts. It's not that everybody needs a trust, but they usually make a lot of sense.
I think we've tried to make a lot of these podcasts, what word do you, evergreen, I think is the term that you use a lot.
Yep.
So that they, the concepts are true,
They are
and
not
carry
episodic.
through.
In other words, you can go back and listen to, and then unless laws change,
Right.
then they work. So
Which is why you want to check with professionals, is
Yep.
to see if laws have changed. And so you want to check with attorneys and financial advisors and accountants to see what's changed. But generally, the podcast that we've done will provide you with great concepts and help you ask a lot of the right questions.
yeah, which is good. Anything else on today's subject, Rex?
No, but we really made this fun.
Well, I'm glad you had a good time, Rex. Thanks for being here. I really appreciate Brandyn Smith and Rex Baxter from planwithbaxter.com. So if you do have any questions, please go to planwithbaxter.com, and that will make it fairly easy for you. You can, if you found value in this podcast, you can consider supporting us at buymeacoffee.com/Banyan Media, where you just give us all your money and we'll help you invest that through us. I'll just spend it all. That's all it is. This has nothing to do with these two in the room.
And in the next podcast, we're going to talk about debt.
You sure as hell are. So that's how that goes. You can watch and subscribe to us on YouTube at Through the Pines. So if you're listening to this via audio only on the podcast version, you can see our wonderful, beautiful faces on the YouTube at Through the Pines. You can like our Facebook page, facebook.com/Pines Podcast. And we're also on the Instagram at Pines_podcast. Thank you for listening to this episode. This has been Through the Pines, reminding you to use yesterday's dollars to finance tomorrow's dreams.